Okay. Hello, everyone. Good afternoon. My name is Yvonne Loraldi. I am one of the special education social workers in Northside. Thank you so much for joining us this afternoon. Our topic today is guardianship and alternatives to guardianship. And also joining us from Northside are two of our transition specialists, Miss Lisa Santoyo and Jeanette Driffel, and they'll wave to you guys. And our presenter today is Mr. Sam Davis, who has provided information for our families for several years now. He historically has worked for Catholic Charities, but is now in private practice with the law office of Samuel Davis. He's in practice on his own now, and he'll be your presenter today. If you have any questions, please place them in the chat, and we will be monitoring the chat for those questions, and we'll try to hold off till the end, till Mr. Davis is done. But if there's something that you just have to say at that moment, just raise your hand or open up your your microphone. So with no further ado, Mr. Davis, you want to go ahead and begin?
Great. Thanks, Yvonne. And thanks also to Jeanette, Lisa, and y'all staff. And appreciate again the opportunity to speak to you guys, speak to parents and families. And like Yvonne mentioned, I'm in private practice. Kind of since COVID, I was in, as Yvonne also mentioned, I was with Catholic Charities for about 4 years or so. And but now I'm back in private practice. I've been practicing since 2011 and mainly in this area, guardianship, but I also do some probate work, estate planning. But I've really enjoyed the field of guardianship work just for the main reason is just getting to know the families and being able to help parents and, get this guardianship in place, for their son or daughter. But with that said, I'm going to go ahead and share my screen and let's see. Yeah, let me get to my desktop here. And because I'm going to pull up my little PowerPoint presentation. Okay, so we're going to talk a little bit about guardianship, but also there's a kind of a catchphrase in the guardianship world of less restrictive alternatives. And I put my contact information here, my email and phone number. And I was also going to share my PowerPoint with Yvonne at the end of the presentation. And so if you miss a slide or you want to kind of, look back at some of the information, I'll share the PowerPoint with you guys. But so I get this question a lot, from when I first meet with parents and families. Why do I need a guardianship? I've been my child's parent for 18 years. It doesn't make sense. And I agree with you. Sometimes it doesn't make sense. You've been able to make decisions for your son or daughter for all this time, but now once they turn 18, though, they're an adult, and so a guardianship might be needed. But if you can avoid a guardianship, that's great too. And so we're going to talk about maybe some alternatives to guardianship that might work or might not work. But really, a guardianship, the purpose of it is to protect and advocate, for your child. And so it's not we want to take these rights away. It's more of we want to protect this person. We want to make sure, that we're advocating for them, for their health or medical, what have you. But so when you turn 18, you think about some of the rights. Some of these rights, obviously, you can get before you turn 18, like being able to drive, but you're able to vote. As an adult, you're able to make a contract with somebody, like say to buy a car, or your right to make financial decisions, your right to marry, your right to make medical decisions, your right to determine your own residence. So these are all the rights that you're able to make as an adult. but we know that sometimes individuals can't make those decisions for themselves. And so what do we do? Well, one option again is doing a legal guardianship. And it's goes through the probate courts here in Bear County. So if you're I'm assuming everybody on the call lives in Bear County, but in Bear County, there's three probate courts. We just added a third probate court this last year. But so when you probate court, if you're familiar with the term probate, it's normally when somebody passes away and you have to present the will to the court and kind of file all this paperwork. Well, the probate courts also handle guardianships. And so if you're hiring an attorney, you want to make sure that they're guardianship certified. And so an attorney who practices in this area, they have to do, I think it's like 4 hours of a like a CLE, course to be able to take on these cases. But um, so the the person, so your attorney will file an application with the court, and the court will determine, is this person incapacitated? And that person is the ward or the proposed ward. Um, okay. And then normally, you have a family member who's the guardian. The guardian might have full authority or partial authority, and I'll kind of talk about that here in a little bit. But there's a couple types of guardianship. Most of the guardianships, when you have a young person who's turning 18, you only need a guardianship of the person, because you're just really the main purpose of that type of guardianship is you're making medical decisions, you're determining their residence, um, and so somebody turning 18, they may not have a lot of financial assets. Maybe they're just getting SSI. So there's really no like estate, if you will, to manage. And so usually guardianship of the state is more like, say, if you're a guardian for an elderly person who has several properties and cars and bank accounts and other assets that you really have to manage, well, then you might need a guardianship of the person and the estate. But again, for for the purposes of probably the most folks, if not all on this call, it's this guardianship of the person. It's kind of what you would be looking at. Okay. Well, again, what is an incapacitated person? You see the little asterisk there. Well, if you're ever bored and want to look at the laws that govern guardianship in Texas, it's under this Texas Estates Code. Again, you'll see a lot of laws in that code dealing with what happens when somebody dies. But again, guardianship falls under this set of laws, the Texas Estates Code. Okay. And so they have defined an incapacitated person in the Texas Estates Code as somebody, again, because of a physical or mental condition, is substantially unable to provide food, clothing, or shelter for himself or herself, care for their own physical health, or manage their own financial affairs. Okay. Um, so just kind of a nutshell on this slide. It's the process itself is fairly straightforward. Again, if you're hiring somebody, they have to be certified, and they have to be kind of knowledgeable about how these cases work. But if they're pretty straightforward, I get the question, well, how long does the case usually take? Well, it varies kind of by case to case, but if I had to give an estimate, maybe like 3 to 5 months is kind of the general rule of thumb about how long these cases take, like from start to finish. Sometimes, things, there's hiccups or speed bumps along the way, but that's kind of a good estimate I would usually give folks, is like about 3 to 5 months. Now, sometimes unfortunately, you have a situation where, let's say, maybe you have parents that are divorced and both of them want to be guardians, but they don't want the other person to be guardian. Okay. Now that might be turned into a contested matter well, then, it might delay things, obviously, because you have to, the court and judge has to kind of figure out, okay, well, both these people say, I want to be guardian, and they really can't work together, or it's not going to be a feasible arrangement. So we got to figure out the best interests of the individual as far as who should be guardian. Okay. So, but again, I go back to the less restrictive alternatives should be always considered first. So when I meet with new clients, I say, okay, I understand you're interested in a guardianship for your son or daughter, but what about these other options? Could they execute a power of attorney, for example? And then sometimes the feedback is, well, no, they can't read or write, or no, you know, they are, um, there's uh, they're mentally disabled. And they wouldn't be able to understand it. Okay. And so, but at least we have to kind of figure out, okay, are there other less restrictive alternatives available? So this next slide is kind of a summary of some of the different less restrictive alternatives, supports and services, which I'll have kind of a slide on here in a second. But for example, like Meals on Wheels. Well, let's say, again, it maybe not really apply to a young person, but say an elderly person, maybe the only big need they have is they can't get meals for themselves. And, they don't have the technology or resources to do like, DoorDash or something. But so maybe Meals on Wheels is really the big need. And so if we get something like that in place, well, maybe we can avoid a full-blown guardianship. Okay. So again, it's kind of my job as an attorney, and whichever attorney you work with, is their job is to kind of go through some of these things and kind of figure out, okay, well, what are the big needs here? And can other options fill that need other than a guardianship? Supported decision-making agreement, I'll talk about that in a second. And then powers of attorney. I'm sure many of you are familiar with powers of attorney, but I'll talk about that in just a second. So these are just some examples. I won't kind of dwell on this slide too much, because a lot of these will apply more towards maybe elderly individuals who are in need of a guardianship, or maybe, again, we can avoid a guardianship by getting some of these supports and services in place. But these are just examples of things like, okay, well, if we get some of these things in place, maybe we can avoid a guardianship. Okay, like someone to manage their medication, caregivers. Maybe the issue is they're not able to clean their home anymore, and so maybe bring in a cleaning service, once a week or twice a month or something. Home alterations, food delivery, life alerts, cameras, and then do we need to add different pieces to help them manage their health care or their finances? Okay. Like this True Link card, which I'm a little, I haven't worked with very much, but it's, kind of one of these. I'll talk about this like an Able account is kind of similar to this, but True Link card where you can kind of manage somebody's spending. Let's say if somebody, young person who, you want to give a little bit of independence to, but you also want to make sure they don't, you know, blow thousands of dollars, online or something, where you might be able to do like a TrueLink card where you can monitor their spending and kind of set restrictions on what they're spending on. Okay, so these are some of the other less restrictive alternatives. Like sometimes I've done powers of attorney. This is medical POA, financial POA. Somebody may say high functioning on the autism spectrum. Maybe instead of a guardianship, you can do a power of attorney. So that young person, once they turn 18, they can sign power of attorney documents saying, I want my mom, or I want my mom and dad to be my agents. And, so they can help me if I need it. Okay. Now, the only thing to keep in mind though is they'd have to be able to understand, and, they don't have to understand every single, there's legal jargon thing, but they have to just have a basic understanding of what they're signing. But sometimes I've done power of attorney documents. Now, the only thing to keep in mind on power of attorney, though, is you have to be careful because let's say, that person, the young person can still make their own decisions. Okay. Now, hopefully they'll ask their agent for help. Um, but they can still do things for themselves too. So there's some danger or risk involved with power of attorney agents, but those can be good documents to have. Some of you may already be rep payee for your son or daughter, but that's also a helpful alternative to guardianship sometime. Doing a joint bank account or a convenience account. Okay, so you have somebody, say, young person again who's high functioning, you set up an account and you're on there as a convenience account person where you can deposit money or write checks and things, and kind of help that individual. Special needs trust. I think I have a slide here for special needs trust here in a second, so I'll skip that. But supported decision-making agreement, that's a document that says, actually, I think I have a slide on that too. So let me hold up on that one. But you can also, there's release forms saying, okay, I give this person authorization to get information about my medical care or education. And so those are some release forms that you might, again, the young person has to be able to understand them and execute them for those forms to be an option. And then ABLE accounts, and I think I have something on ABLE accounts here in a second. I'm going to skip to, let's say, so the special needs trust. So this one is, so on the special needs trust, you can, let me actually, I work with the ARC of Texas. It's an organization in Austin. And the nice thing about it, special needs trust, is that, you have, let's say somebody comes into an inheritance or a settlement from a personal injury lawsuit, and the young person's on Medicaid, right? For example. And so, you know, Medicaid, if they see that the young person has more than $2,000 in assets, well, they'll say, well, you don't need us. You don't need Medicaid. We're going to kick you off Medicaid. Well, to avoid that, you can set up a special needs trust. And again, I often refer clients to the ARC of Texas, and here's their website. But that's again kind of a nice option that you could look into. And I think other family members can also contribute in that. I think, yeah, I think so. But again, special needs trust is a good option for a lot of families. Okay, so let me skip to supported decision-making agreements. I won't linger on this too much, but this is basically a document where the young person says, okay, I want my dad or mom or both to help me if I need it. The example I have here is like, if you think of like an advisory board, well, if you have an advisory board, it's kind of different than like your board of directors who actually make decisions. The advisory board, they're just kind of a sounding board where they give advice and suggestions. That's kind of like with the supported decision-making agreement. So the possible downside is it doesn't really have much legal authority. You're just kind of saying, okay, I'm going to help you if you ask for it. And the young person saying, okay, well, I'm going to ask you for help if I need it. Okay. So that's the supported decision-making agreement, basically. ABLE accounts I mentioned, that's where you can put up to $18,000 a year into this ABLE account. The maximum over a lifetime is 500,000. So, once you hit 500,000, it kind of maxes out. But the nice thing about ABLE accounts is that again, friends and family can kind of put money into this ABLE account, like grandparents, they say, yeah, well, they hopefully understand like, well, I can't write you a check for $5,000 because you're on Medicaid, but I'm going to put some money into your ABLE account. And kind of like that other card I mentioned, the ABLE program has this little prepaid debit card. Okay, again, so it's a nice program because you're encouraging some autonomy and independence, and say you go to a mall or you go to the gas station, and this young person say, yeah, I want to kind of buy something here for myself, or I want to use my able card, and just to try to encourage as much autonomy and independence as possible. But texasable.org is the website if you want to check that out. Okay, so back to guardianship, which again, a lot of you probably will have kind of questions about. Sometimes again, a guardianship is the best option for families. So, but you can have what's called a full guardianship or a limited guardianship, depending on the situation. So let's say somebody, again, maybe high functioning, who they've expressed interest in voting or driving. Well, you can tailor the guardianship to say, okay, judge or court, we're going to, as guardian, I want to be able to have these powers, but we're going to allow our son or daughter to be able to vote, or we want them to be able to drive at some point. Okay, so you can tailor it. It's not just like um, but okay, so what are the qualifications to be guardian? Well, some of these are kind of common sense, but you have to be 18 years old. You can't have convictions, criminal convictions regarding these kind of following categories: sexual offense, aggravated assault. Again, it's kind of common sense, but sometimes people say, well, I had a DWI 30 years ago. Is that going to be a disqualification? Probably not. You know, but sometimes, well, all these cases, you fill out this thing online, and a background check is generated in Austin at this agency, and then the results are sent to the court. So sometimes the court will get this background check from an applicant or from a person who wanting to be guardian, that will just have like a basic, like 3 or 4 word, maybe even like, you might say like DWI or something, or very not any details. Okay. And so then the court will contact me and say, well, um, you know, can you tell us a little bit more about this? Or just tell your client at the hearing, the judge might ask them about this. Okay. Now, if it's something where it involves, violence, assault, again, those are be some things that might disqualify somebody, but we have to kind of get to the, what actually happened. Okay. Some of the other qualifications, again, this is all comes from the Texas Estates Code, but if there's a conflict of interest, say you owe your son or daughter $10,000, or again, there might be a conflict of interest. Say, you've sued them for some reason. Well, that might be a conflict. So there's like crimes of moral turpitude. Again, this comes from the Estates Code, but that might, if there's like fraud, deceit, some kind of violence, again, those might be disqualifying factors. Okay. So who may serve as guardian? I get this question a lot. Yes, there, the people ask, well, can we be co-guardians? And the answer is yes. Parents can be co-guardians. Say if bio mom and bio dad are divorced, can say bio mom and stepdad be co-guardians? Yes, that's also possible. What about bio mom, bio dad, and they're divorced? Well, the code does allow for that if they're joint managing conservators, which is, again, kind of a legal term. Basically saying, we both have, rights as parents. But the only courts are usually in favor of that agreement, and you can kind of understand why, say, again, maybe the divorced parents get along great, and I actually have seen it a couple times, but again, the court usually frowns on it because maybe things are great now, but maybe, but what about 5 years down the road and, you know, mom and dad are fighting and they can't agree on anything. Well, that doesn't really help us as far as the guardianship goes. So, um, anyways, but it is possible. Um, I'm actually going to skip this one. Kind of gives them kind of the details on the guardianship process, but that's kind of getting into the minutia of it. Now, when can you file an application? Well, it's really your attorney is filing an application, but it can be filed within 6 months before the young person turns 18 or later. Excuse me. I have families contact, well, my son is 19 years old now, and we just kind of put this off, and um, that's fine too. I mean, it doesn't have to be right when they turn 18 or right before they turn 18. You can kind of do it any time. Um, the hearing, so the hearing though can't say if somebody contacts me 5 months out. I was like, well, that's fine. We can kind of start the process, but the actual hearing can't be held until the young person turns 18. So sometimes you have to wait a little bit if you, but so what's needed for guardianship case? Well, the main piece of medical evidence is this form. It's called the Healthcare Provider Certificate of Medical Examination. And CME is kind of, there's been kind of the abbreviation. Um, so sometimes, you might see that. Well, our peer people talk about the CME. Well, that's the medical form that is submitted to the court, and the judge will look at, and because we want some, we're not medical professionals, the judge, the attorneys. And so, and we just not going to just, somebody might apply for guardianship. Well, you can't just say, this person needs guardianship and not provide any kind of medical evidence of that. Okay. And so that's the reason for this form. So again, your attorney provides you with this form. Usually the parent or whoever's applying to be guardian will schedule an appointment. It can be done by a physician, psychologist, or advanced practice registered nurse. And they do an examination, they fill out the form, and but they're just included a note here. It can't be 4 months older. So sometimes I've had clients contact me or potential clients say, well, my son is 17 and we just took the initiative to go ahead and do this medical form. Okay, well, that's fine, but you're probably gonna have to have it redone when we actually apply, because when we apply for guardianship a year from now, well, this report's going to be over a year old, or this medical form's going to be over a year old. Okay, so you might have to go back to the doctor to get updated. So the point is, we want to provide recent information to the court. Okay. And the form itself is like 5 pages, but it'll ask questions like, is the proposed ward totally incapacitated or partially incapacitated? Well, if it says partially incapacitated, well, then that might be a conversation we have about, well, do we want to retain some rights for the ward? Do we want, have they expressed interest in driving or voting? So maybe we can tailor it. A lot of times though, it says totally incapacitated. And so this other question is on the form. Is improvement in the ward's physical condition and mental functioning possible? Well, if the doctor says yes, sometimes we have to kind of clarify that. Well, is it yes because maybe they can improve on certain ADLs, or the activities of daily living? Maybe they can improve on their speech, or maybe they can improve on they can do more things for themselves, like cook, but is it would they be able to totally care for themselves. And again, a lot of time, normally it's the answer to that is no. They're always going to need some assistance. Okay, so sometimes the court would just want to clarify that, because if the doctor says yes, improvement is possible, well, you have to kind of nail down sometimes at the hearings. It's like, well, you have to ask the guardian, okay, well, what does that really mean? And would they be able to live on their own at some point? And again, the answer is usually no. Okay, in these situations. Um, okay. Now, this is in the code. It also says, it can't just, it has to be recurring acts or occurrences in the preceding 6 months, to it can't just be somebody. I've had a few instances where parents are, their son or daughter is just making bad decisions. Well, that doesn't make you eligible for guardianship. So it has to be, again, a situation that's been ongoing and again, a lot of these situations, as we all know, it's, either from birth or from a young age, it's not just something that's been happening in the last, year or so. So back to I touched on briefly some of the rights that are affected in a guardianship. And again, you can kind of tailor these, but normally in what's called a full guardianship, the the young person, they lose their right to vote, drive, determine their residence, make decisions regarding marriage, owning and operating firearms and ammunition, consenting to medical, dental, psychological, or psychiatric treatment, and handling financial affairs. Okay. Now, other than this list, again, it's, you know, the law kind of encourages guardians to encourages the young person to keep other, legal and civil rights as much as possible. Okay. So again, just the idea of encouraging as much independence as possible. Okay. But these are kind of the main, when you have like a guardianship order that you submit to the court or your attorney submits to the court, these are the rights that you'll usually see on there that are affected. Okay. Let's see. And then again, I already mentioned that kind of full versus limited guardianship. Now I have had some cases where it started out as a full guardianship, but say like 10 years down the road, young person's now 28 years old, and the guardian contacted me and said, my son really wants to start driving now. He's expressed interest and so we went back to court. We modified the guardianship to allow him to be able to drive. Okay. And we may have added voting too. I can't remember, but anyways, the individual still needs help with making medical decisions, but they wanted to be able to, restore that right to drive. So we were able to go back and modify the guardianship. Okay, again, I've kind of touched on these already, but these are some of the powers and duties again as guardian. You have the ability to establish the ward's legal residence. Sometimes this will come up, say if your son or daughter is in a group home and maybe that group home isn't working out. Well, as guardian, you have the authority to go in and say, look, this isn't working out. We're going to move him or her to another home or something. So as guardian, you have the authority to do that. Okay. So at the end of kind of your case, at the end of the legal process, you'll get what's called letters of guardianship. It's a form from the court, and that would be the form that you show any third party. So say you're at the doctor and the doctor says, well, your son is 18 now, he can make his own decisions as an adult. Well, if that's not the case, that would be the time where you might, I've had some clients say, well, yeah, we always kind of keep a copy in the car. or we have a little flash drive on our keychain, that has a copy of this letters of guardianship. And so that would be a situation where you would want to show that letter. Again, it's just a form, but you would show that to the third party and say, well, I'm his guardian, so I'd like to be in the exam room with them and be able to help make these decisions. The forms expire 16 months after they're issued. So the only thing you have to do, some people say, well, do we have to go back to court every year? And how does that work? And no, it's just you have to submit this annual report to the court, and just kind of gives the court an update. The form may not, the information that you put on the form again may not change from year to year if everything is stable, but it'll ask questions like, did so and so, did the ward go to the doctors this last year? Did they go to the dentist this past year? Are there any changes to their medical history or medical situation? So it just gives the court an update. Again, if there's some like major concerns or issues, well, you could kind of put that on the form, and if you're needing some help maybe with certain things, and the court can also be a resource. So, but it's on the court's website. But again, that's not until like the year after. So, like say if you had a guardianship and we went to court today, a year from now is when you would have to do kind of your first annual report to renew that. Okay, so sorry, it would help if I realized I didn't even start the PowerPoint. So, but I'm just kind of clicking through the slides here. But yeah, if again, my email and phone number is here. If you have questions, or if you need an attorney at some point to be able to do guardianship, feel free to reach out. But again, I'll share this PowerPoint after the presentation. But yeah, if there's any questions, or I'm happy to answer those. Let me stop
It
sharing
looks
my
like we do
screen.
have two questions in the chat. The first one is, can you have an able or special needs trust with legal guardianship, or does it have to be one or the other?
No, it's my understanding you can have both. Yeah, I think, yeah, they're just kind of independent from each other. So yeah, I've heard of families who've had both.
The second question is, if a child's completely nonverbal with a profound intellectual disability and isn't able to care for themselves because they are significantly impacted by their disability, what happens if a parent doesn't apply for guardianship? Does the state step in to be their guardian?
No, not necessarily. I've gotten that question quite a bit. No, I mean, not necessarily. I mean, not like, the state won't come in and say, yeah, we're going to be this person's guardian. Sometimes though you'll have interested parties or family members or medical professionals, that, let's say, maybe the parents aren't, kind of moving forward. If a guardianship, yeah, is clearly needed, you see sometimes where you'll have other people kind of write to the court and say, look, I think this person really needs a guardianship. And the court will often respond by appointing an attorney, like me, or it's called a guardian ad litem. And that person will then kind of do an investigation. They'll go out and talk to the family, meet the young person and then report back to the court and say, look, yeah, I think a guardianship is really needed here. And so again, hopefully that maybe it will encourage the family to say, yeah, okay, we'll go ahead and move forward. And I mean, if finances are an issue, I mean, Catholic Charities, Texas Rio Grande Legal Aid, SALSA, there's SALSA, which is San Antonio Legal Services Association. But so there are organizations out there that will do it if not pro bono, they'll do it at a reduced rate, as far as the guardianship, the process. But so, but yeah, no, I've never seen that where, yeah, like the state will come in and say, yeah, well, we're gonna be their guardian. Obviously the goal is to have family members do it, if it's needed.
And next question was, can divorced biological mom and dad split guardianship? For example, one be guardian for the person and the other for the estate.
Well, again, it's usually guardianship of the estate is not needed for a young person just because, a lot of times they're just getting SSI. And I think it's actually kind of there's a new law that says even if I forget what the income cutoff is, but even if you're getting a small income, you still don't need guardianship of the estate. Um, so and again, the court kind of frowns on that. I've seen it a few times where divorced parents can be co-guardians. Um, but again, the court kind of frowns on that because, okay, maybe y'all are on the same page now, or things are okay now, but let's say what happens if that breaks down, a year from now or 5 years from now. Um, so yeah, but yes, it gets difficult, right? Because you have maybe bio mom, bio dad, they both want to be guardian and they're divorced. And so sometimes one person might just kind of have to step aside and still be involved, of course, as much as possible. But maybe on paper, you just have one person serve as guardian.
So there's a little bit more info to that one, Sam. The
Okay.
parent said that the child does have trusts and other asset accounts through dad.
Okay. Okay. Through the dad, you said?
Yes.
Okay. Well, then, yeah, I guess in that case, yes. If a guardianship of the estate is needed, then yes, you could have one person be guardian of the estate and one person be guardianship of the person. Um, again, just with the caveat that yes, you there might be the judge might push back a little bit, say, okay, I know y'all are kind of in charge of separate things here, but y'all are there might be some overlap and y'all still gonna have to work together. And so they might have to just say, their attorney might have to, and that's the other thing sometimes too, where I'll represent both co-guardians. It's usually again a situation where you have a married couple and I'll represent both. Now in that situation, you might have to have separate attorneys too. You might have one attorney for mom, one attorney for dad. And but again, you kind of have to persuade the judge, like, okay, yes, I understand we're not married, but we'll work together, for the benefit of our son or daughter.
Next question is, can you have two people named as guardian that may not be married, but in case of death have to alternate?
Unfortunately, no. So I think it's okay. So is a question like, say, can you name like a successor guardian? I think that's kind of what they're asking. So let's say if you say
Yeah, I
maybe,
think that, yeah, I think
okay,
that's what they're
okay,
asking,
yeah,
in case one of them passes.
in case somebody passes away. Yeah, you can't really do that. And unfortunately, I wish there was something in place where, yeah, you could, maybe have something in the order saying, you know, if I pass away, I want this person. But what I normally would recommend is like for say, let's say mom is sole guardian and she has an adult daughter who's not disabled, okay? And so she's guardian for the disabled daughter, but she may, I would then maybe recommend doing a will. And so mom could say in her will, if something happens to me, I'd like my other daughter to take over the guardianship. Okay. Now it's not an automatic switch, but it does give the court some direction. So say the mom does pass away and the court, well, we need somebody to take this over. Oh, well, look, we do have a copy of this will that says mom wanted her other daughter to be the successor guardian. Okay, well then daughter would then maybe contact me and say, well, my mom passed away. She wanted me to take over the guardianship in her will. And then, there's just a separate process to kind of get the successor guardianship in place. But yeah, unfortunately, there's not really kind of something you can do in advance of that happening. Now, I guess you can, I just was thinking about it a little bit more. You'll see this a little bit more with, again, with elderly people, but, oh, well, I shouldn't say that. I mean, really anybody, but you could say, there's a form that says, if I become incapacitated, again, you have to be able to execute this form though, but say, if I become incapacitated, I want this person to be my guardian. So that is one option. Again, you'll see, but obviously for somebody who can't execute a document like that, that wouldn't work, but hopefully that answers them.
Okay, next question is, what would one expect when having to deal with a contested guardianship? Would we go through the whole process of home studies, witnesses, etc.? How would the court determine the best fit?
Yeah, it's difficult, and I usually try to stay away from contested matters. But yeah, it gets difficult, right? Because maybe you have two good candidates, and they just you know they can't agree, or they're not one person's not willing to kind of step aside and allow the other person to be guardian. So yeah, you have like you might have character witnesses. Um, yeah, maybe, yeah, like you said, like the question, maybe you have home studies. So it gets difficult, because again, like, I mean, maybe you have two candidates that would be fine guardians, but then the court has to decide, okay, well, but again, it's just, yeah, you present all the evidence that you have, like again, the witnesses, yeah, maybe home studies. Yeah, it's unfortunate. Yeah, again, I think the court tries to kind of avoid that as much as possible because we don't want like a family custody battle to carry over into the probate court. Okay. And again, sometimes it's inevitable, but we don't want you're fighting with somebody for 18 years or less or whatever about custody and visitation. Well, then you go into the guardianship. Well, you're going to have to do all that again, so you have to, sometimes the court will encourage parties to go to mediation. Sometimes that is a good option to kind of to figure it out in mediation before you get it some, 3-4 day trial or something.
Next question is, how does guardianship affect SSI, Medicaid or Medicare, and waivers?
Okay. With SSI, once you turn 18, they're gonna just they'll look at the young person's income, right? Instead of the family or the parent's income, so that sometimes that may affect the amount of SSI someone's getting every month, but um, it doesn't really affect the guardianship though. They're they kind of work independently of each other. So sometimes, young person's already getting SSI, and again, like the example I mentioned, somebody's turns 19, they're already getting SSI, they're already, doing, and it's just, they need the guardianship in place for other things. Yeah, so and then with Medicaid and Medicare, I mean, again, it's Medicaid, I think, is again just that issue of you want to be careful not to exceed the cutoff income requirement for Medicaid. And so again, that's where like a special needs trust might be helpful.
Next one is, if parents are already divorced and dad isn't exercising visitation and there isn't any contact, does he have to sign off on mom being the guardian once the child is 18? And does he need to be involved in the guardianship application process?
No, he does not need to be involved in the guardianship application process, other than, he does, in that situation, he would need to be served, or um, you know, or the better option would be like if he's willing to sign a waiver saying, okay, I understand, but the the big point though is that because sometimes I have, you know, you have clients come to me and say, well, I don't want to notify bio mom or bio dad about this. I want to do it. You know, I don't want to get them involved. They haven't been around in 20 years. And well, unfortunately, we have to give that other parent notice. So if they're not willing to sign a waiver, then yeah, then there's some added cost of, you know, having, you know, pay the constable, the county constable to go out and give them notice. And I mean, because it's a lawsuit and, you know, legally, you know, they're a biological parent, and so you have to give them notice. Or in the alternative, if they kind of willingly sign this waiver saying, yeah, I understand what's going on. So, but yeah, you do have to, that's the only involvement though in a situation like that, that they have to either get served or sign a waiver. And then maybe, you know, a lot of times they don't do anything. They get served and like, okay, well then you just kind of move forward with the case and yeah, you don't have to do anything else.
And then the last question is a continuation of if guardianships affects SSI, Medicaid, Medicare, and waivers, if it also affects grants and scholarships.
Grants and scholarships. I don't know. I guess, yeah, I don't really think that'd be an issue. Like say, I guess.
There are some local community colleges or universities that have special programs for individuals with IDD.
Okay.
Um, they do, one of the requirements for students to access those programs is that they cannot be under guardianship to access those
I see.
particular programs. Yeah.
Okay. Okay. No, that's okay. That's good to know. I wasn't aware of that.
But getting the grants and scholarships, it sounds like it's two different things.
Mm-hmm. Yeah, I mean, right. I guess unless there's some kind of restriction like that, I don't really see that being an issue. Yeah, again, I guess that's a good question though. I guess well, if you're under Medicaid, I don't know, does scholarships or grants affect Medicaid? I guess, yeah, that's a good question.
We have some parents here at Reddix that have guardianship, and the individual's still getting Medicaid and SSI.
Okay, that's good.
And then I believe that's the last question. The recording, yes, will be provided, as well as a copy of the presentation. Does anybody else have any other questions?
Okay. Thank you everyone for joining us this afternoon. And again, thank you so much, Sam, for your expertise and sharing your time with us. And all the parents that signed up will get the recording and the slides emailed to them in as soon as we can get those out to you. And I believe Miss Driffel will be sending those out.
Great. Thank
Okay,
you.
thank you